May I please, Lordship? This is a bail application, my lord. A case registered.
Item 2 and 3 are similar matter, lords. Same offence. This is that Sora court vandalism on the date when the election results were declared. These two persons have been arrested in the matter. It was a mob of thousands, my lord, and only these two have been arrested. Now, only several sections, they've been booked under several sections. Two sections are non-bailable, my lord. Section 353, which is a non-bailable offence, and a summons tribal case, my lord. And Section 3 of the Prevention of Damage to Public Property Act, which is also non-bailable, my lord. My lord, in my humble submission, they were arrested on the 14th, my lord. The other accused persons are yet to be arrested, but them having been arrested, my lord, the offences not being so grave, no human damage has been caused. So, my lord, my prayer is if they can be enlarged on bail, they will face the trial, my lord. The punishments are also not very severe, my lord. I do condemn, my lord, as a counsel, as a member of the bar.
What is the stage of the...
My lord, still under investigation, and only 2 persons have been arrested out of thousands, my lord. The courts below have also rejected.
When were you arrested?
On the 14th of March, my lord.
14th of March.
14th of March. But the punishments, my lord, there's no minimum punishments. These are most of the sections are all summons tribal, my lord. So, my lord, discretion is with your lordship. They will face trial, my lord, if they are enlarged on bail, my lord.
Who's appearing for the state?
I'm appearing on behalf of the state, Your Lordship.
Yes, ma'am. Tell me.
Your Lordship, sections 353 and of the IPC and section 3 are non-bailable offences, Your Lordship. The very fact that they have trespassed into the court premises and put fear in the mind of the judicial officers and the staff here over there in Sora, Your Lordship, is a grave offence in itself. So, Your Lordship, at this stage, Your Lordship, the matter is quite premature. The investigation is still on. There are so many other people who are involved in the case and they are yet to be arrested, Your Lordship. So, my humble submission is that, Your Lordship, the CD may be called for and it may be considered at a later date, but not at this stage, Your Lordship, because this would only encourage them, Your Lordship.
Lord, we have not been booked for causing fear to anybody's life, my lord. We have been booked for causing...
That will come in due course.
That will come in due course, Your Lordship, because the
investigation is, at a very premature stage.
I'm not going into that, my lord. I'm not
Preliminary
going.
stage,
All I'm saying is the sections under which I'm booked and arrested for, my lord. I'm not going into the merits of the case. As a member of the bar, I totally condemn, my lord, these kinds of actions.
Heard Mr. Piliman Nongri, Learned Counsel for the petitioner, who has submitted that this application for grant of bail made under section 439 CRPC has come with a plea on behalf of the accused person, Shri Tars, represented by subdivision within the East Khasias district. Next. In view of the volatile situation, as could be expected when such an event has taken place, there was some confusion in which led to a chaotic situation and violence, where the crowd, apparently being unsatisfied with the declaration of some result. Next. Long story short, the ensuing violence has resulted in damages to public property and also an allegation of trespass, whereupon an FIR was filed. By the Judicial Magistrate First Class, Sora Subdivision. Next. Pursuant to the said FIR, the police has investigated into the matter, and among others, the accused husband of the petitioner was also arrested. The FIR was registered as
Sora PS case number, my lord, 4/3 2023.
under section 147 oblique 148 oblique 353 oblique 447 oblique 34 oblique 427 IPC, read with section 3 of the Prevention of Damage to Public Property Act 1984. It is submitted that the case is at the investigation stage. At this juncture, the learned counsel has submitted that the accused
He had have no criminal antecedents, my lord. Chaos broke out, my lord, and
what about your complicity?
my lord, we have not gone into that. But certain, my lord, videos that on the basis of which they were arrested of the crowd, they were part of the crowd.
Kunum tukong tukalas. Was part of the crowd and was arrested randomly. It is so prayed that bail may be granted to the accused to allow him to defend his case, considering the fact that out of the array of sections alleged against him, only 2 are non-bailable, including the section 3 of the Prevention of Damage to Public Property.
Appearing as AAG, Your Lordship.
AG, not PP.
No, AAG, Additional Advocate General.
Ms. Tiangi, Leonard AAG, appearing for the state respondent, has strongly objected to the prayer made on the ground that the investigation has just started and it is too premature for consideration of bail at this juncture, considering the fact that there not only was damage to public property caused, trespass was also evident, and to boot, minds of the judicial officer and staff of the sub-divisional court has to be taken into account, which will be revealed in course of investigation. This court has given careful thought to the submission made. To 3/2023.
14th.
Sorry. On
14th.
14/3/2023. Bail is definitely a discretionary power to be exercised by the court, albeit on consideration of the attending factors and guidelines provided from time to time by the Apex Court and the statutes. This court would have to refer to the evidence or the report of the IO in this regard. This court is in agreement with the Leonard AAG that the stage is too premature for grant of bail at this time, at this point of time. Consequently, this petition is devoid of merit. The same is hereby dismissed.
But liberty to approach the...
That you can always do. That you can always do.
In such a matter, my lord, where the complainant is as such, if that liberty is granted, so that as and when the circumstances change...
The petitioner is, however, given the liberty to take recourse to.
And today we see nobody is also appearing. Perhaps the submission was made only to ensure that a stay would be given, my lord.
Anyway, that apart, if there is an intention to settle the matter eventually, so we'll leave it at that.
They have shown the intention, but my lord, unfortunately they never called, never contacted, nothing, silent.
Who's appearing for the petitioner?
Nobody has turned up also today, my lord.
Who's appearing for the petitioner?
Nobody has turned up also today, my lord.
Let's put it to next week and see how it.
1 week, my lord, lordship.
None appears with the petitioner. Mr. K.C.H. Gautam, the Red Counsel for the respondent, is present for the is present. On submission made, list this matter to 1 week.
Obliged.
Item number 5.
My lord, this matter relates to ARP's matter. To continue the argument, last time I entered with the part of the jurisdiction matter, because my friend has raised the jurisdiction. Now, please,
Article 12 matter.
my lord.
My lord.
The Article 12.
Yes, article, my lord. My friend said that the writ is not maintainable against the ARPS school.
The RPS not being amendable to writ.
Right.
But that has been settled by the
No,
Supreme
my
Court.
lord. Because this court, my lord, this court has the power to see whether any order of this High Court or even the Supreme Court, whether that order is in consonance with law, my lord.
First amalgamation.
My lord, first is the maintainability. I have to overcome that one since my friend has raised that issue. And now, my lord, I'll point out one page, an annexure, and to be supported by the judgment. Lordship, kindly see the additional affidavit filed by me on 25th October 2022, page number, my lord, 21, page number 21. My friend has given a reply saying that all the financial grants are coming from regimental fund, my lord, though the record says a DGR education fund. Be that as it may, but the only one annexure can also show that they are not a
Yes, you're referring to
page number 21 of my additional affidavit.
dated
Dated, my lord, 25th October 2022.
It's not here.
Lordship is looking to the brief of WPC number 217. 217. McCann Kengo versus Vidinabinde. Yes, it will be there. Page number 21, ma'am. This is the RTI filed by the lawyer for some of the petitioners in 2013, inquiring the status of the school and as well as the funding.
Yes.
Well, the contains, may I read, my lord? With regard to the said fund which the ARPS receive, I request you to kindly provide the following clarification and information. From where the said corpus fund and DGR educational fund comes from, how the said fund, corpus fund and DGR education fund is created or formed, whether the said corpus fund and DGR educational fund of DGR comes from the Ministry of Home Affairs. These are the queries made by the lawyer on behalf of the sum of the petitioner. And the reply to this is page number 23. The next page, page number 23.
Yes.
My lord, the reply is this, my lord. It is to inform you that the Assam Rifle is exempt from forwarding information sought by you under RTI as per Section 24 and Schedule 2 of the Act. The appellate authority for this organization is Additional Director General, Director General Assam Rifles. So they say, one hand they say that ERPS school is purely a private school. Assam Rifle has nothing to do. Now, in the left side, they are saying that no, you cannot seek information with regard to the school because it is exempted. An exemption is given to the certain organization under the Act, and they are including that one. So ARPS is put under that category, exemption category. So this is absolutely, my lord, indication that the ARPS school is pervasively controlled by the Assam Rifles performing public duty. Now, other judgments, the lordship, earlier occasion we have a place referred to. Now, subsequent to that, earlier division bench and Supreme Court judgment also, another decision was taken, passed by this honorable court. May I take judgment? Here the ex-principal filed a writ petition for the benefits, and this order was passed on 25th July 2018, and the writ petition was allowed.
Yes.
Well, an operative portion would be para 9 of that very judgment. There also writ petition was allowed, relief was granted. So if this honorable court do not have the jurisdiction, relief would never be granted. But relief has been granted, they accepted, they have complied with. So they cannot say that no, writ petition is not maintainable before this court. They cannot say that one. Now, with regard to that jurisdiction matter, the issue, well, the one printed. This is not the one. Not this. Yes. Now, like, all right. Lordship, kindly see the para 11. Now, each issue has been settled already. Laid out on litigation till Supreme Court. And they cannot raise that issue again and again. About res judicata. Lordship was earlier indicated. Para 11, Lordship, kindly see. I refer to relevant portion of res judicata.
This is not reported.
It is. It must be a reported one, my 2019 recent judgment.
Where is the citation?
This would be available even in the SSC.
See, I have time and again requested the council, if you cite a decision, let it be a reported one, or otherwise this downloading and printing from Indian Kanun.
But we will supply, right? We will supply the reported.
Because it's not reliable.
We will supply the reported one.
Please.
Para 11, my lord.
So,
we will compile the list of decisions, my lord, and submit to this honorable court.
what is the date of order?
Date of order, my lord, 30 April 2019.
Para?
Para 11, my lord. I flag it, my lord. The flags. May I just read out 11 portion? The learned counsel for the petitioners had drawn our attention to paragraph 24 of the decision in Manmohan Sharma's case Supra, which refers to the case of one Tanvir Singh, whose writ petition had been allowed, and order had attained finality as it was not challenged before the division bench or before the Supreme Court. Termination of services in the case of Tanvir Singh, it was accordingly held, was not justified in accordance with law. The reasoning given in paragraph 24 and 25 in Manmohan Sharma's case Supra relating to case of Tanvir Singh would reflect the difference between the doctrine of res judicata and law of precedent. Res judicata operates in personam, that is matter in issue between the same parties in the formal litigation, where law precedent operates in rem, that is the law once settled, it is binding on all other under the jurisdiction of the High Court or Supreme Court. Res judicata binds the parties to the proceedings for the reason that there should be an end to the litigation, and therefore subsequent proceeding inter se parties to the litigation is barred. Therefore, law of res judicata all concerns the same matter, where law precedent concerns application of law in a similar issue. In res judicata, the correctness of the decision is normally immaterial, and it does not matter whether the previous decision was right or wrong, unless the erroneous determination relates to the jurisdictional matter of that body. But the law is very clear. Now, here the same parties, ERPS and the writ petitioners, round of litigation again and again. That matter reached the Supreme Court and decided already that writ is maintainable. Now, therefore, between me and the respondent ERPS, the issue has been settled in the formal litigation. Neither me nor my friend will have the right to reopen that issue. That issue become, my lord, settled and attain its finality. So it is too late for my friend to raise that this honorable court has no jurisdiction to exercise judicial review over the action taken by the authorities with regard to ERPS matter. Now, this is with regard to, my lord, jurisdiction. And the second issue that relates to the transfer matter. Earlier occasion, my lord, in few occasions, I have invited lordship attention to certain rules of the. Now, this transfer matter started from WPC number 118. Sebastian, my lord. Sebastian, just leave it aside. My lord, may I recollect the memory? Earlier occasion, we have said that the ERPS was the only school established by the Assam Rifles under the Society Registration Act. This was continued. It is a residential school. There is no branches, there is no regional offices, other places. Only station in Shillong. Therefore, at the time of offer of appointment, this was made known. In the advertisement also, there is no term of transfer. Even appointment letter also, there is no condition of transfer. Even the contract of service signed between the parties also, there is no condition which spells out that service is transferable. It is not there. Even, my lord, the school rule books framed by the ERPS also do not contain at all the provision for transfer.
Because you see that it is a residential school.
Residential school. Only one. My lord, for instance, we can say that Supreme Court of India. There is only one Supreme Court of India. There is no question of transfer in the service rule of the Supreme Court. Same thing, my lord, here at the ERP school, since only the sole school, it doesn't contain transfer. Other parts of service conditions are there, promotions, arrears, my lord, disciplinary proceeding, duties, whatsoever. GPF, it is there, but transfer is not there. So it is only a.
But eventually, you see, when ROS came in the picture,
my lord.
where the rules,
Yes.
modified or amended to include transfer.
Right. There, ROS, my lord, when ROS came into picture, 2016-17, they introduced the provision for transfer. Now, see the amendment made by the respondents. They have filed two affidavits. First affidavit, may take lordship attention. They have taken two grounds. First says that, my lord, transfer is a service condition. Therefore, I have no right to claim against that. Second is, my lord, ROS rule has mentioned. Now, one thing they say that service condition, it is already there in the service rules of the ERP school. Other side, they said, no, we introduce amendment and later on we insert it. So they are taking a dual plea, my lord. I'll show, my lord. Lordship, kindly see affidavit filed by my friend, which I received on 7/7/2017, affidavit in the position.
That is in
WPC number 118.
Dated?
Dated, my lord, I received on 7 July 2017.
Yes.
It is squared by Mr. Anil Kumar.
Yes, it's here.
My lord. two parts are there. First part, my lord, may I refer to para 12 and 14, and second part, para 11 and 15. Para 12, Lord, can you see? Para 12, running page 6. My lord,
Yes.
my lord. The averment made in para 12 of the writ petition is denied by the answering deponents, and the petition is put to strictest proof thereof. On the contrary, it is related that the clause 15 of contract of service relied upon by the petitioner specifically provides that the petitioner will conform to all the rules and regulations in force in the school and shall carry out all such orders and direction as he shall from time to time receive from the managing committee, principal, or any authorized member of the staff. Clause 15 of the contract of service and the rules governing the school being clear and ambiguous, there is no reason for terming the transfer order as arbitrary and illegal, and the contention that petition has been transferred to the high school where the subjects presently taught are available in the school curriculum has no substance in it and is liable to be rejected outright. That is one claim. They are referring to clause 15. Lordship, kindly come to para 14. It says that para 14, writ petition is vehemently denied by the instrument respondents, and the writ petition is put to the strict proof thereof. On the contrary, it is humbly submitted that issuance of transfer order dated in such would not in any manner lead to any violation of undertaking given by the respondent authorities as recorded in the order dated such, inasmuch as transfer is an incident of service, and the petitioner would be entitled to service condition, pay, and other benefits attached to the post, and that the petitioner shall be entitled to the same service condition, pay, and other benefits as he is receiving, and entitled his present posting. As such, there is no alteration, change of service of the petitioner as alleged in the writ petition, and therefore it cannot be termed as bad in law and illegal arbitrarily. Now, my lord, may I take the what is clause 15? The clause 15. It is available in my writ petition. Well,
Clause?
Lordship, kindly see, come to my writ petition, page number 29. 29. They say that the power of issuing this transfer flows from clause 15 of the contract of service signed between the parties. May I come to that, Lordship, can you see page 29? The clause 15 is in the middle.
Yes.
Well, it says, the party number one shall conform, party number one is the employees, to all the rules and regulation in force in the school, and shall carry out all such orders and direction as he shall from time to time receive from the managing committee, principal, or any of the authorized member of the staff. So they say that the power of transfer is already here. That is his first limb of contention. It is, according to me, my lord, it doesn't relate to, my lord, the transfer. They said rules and regulation at that point of time, rules and regulation, my lord, I've compiled it. There is no provision for transfer. Now, second limb of his contention is, my lord, page number para 11 and 15 of his affidavit, saying that now we introduce the new rules, my lord. Thereby, my lord, transfer is one of the conditions. Lordship, kindly see his averment in para 11 and 15 of the affidavit.
Yes.
May I take, my lord, para 11 first?
Yes.
That with regard to averments made in para 10 and 11 of the writ petition, it is stated that Assam Rifles Public School Society, ARPS, having been merged with the Assam Rifles Welfare Education Society, ARWIS, in terms of the minutes of the meeting of the governing body held on 28 such conference or such, and communication to that effect having been made to the Registrar of Society Shillong, and no objection received from the Registrar of Societies, the ARWIS rules and regulation have been made applicable to all the schools under the Assam Rifles Public School Society, which provide for inter-school transfer of regular and permanent teacher staffs every 3 years, regularly service at a location. They say, as such, the posting orders essentially being in terms of the said rules and amendment, made thereto in the meeting of Sons and Sons and duly approved by the Registrar of Societies Meghalaya was issued due to existence of service and just and reasonable and does not deserve to be interfered with. Since, my lord, it continues, my lord, and may I continue para 15. Para 15 also. Is with regard to para 15, 16, and 17 of the petition is answering the opponent denied and petition is put to strictest proof thereof. On the contrary, it is stated that transfer being an incident of service, there is no requirement to mention or even indicate the public interest involved in the such transfer or mention any reason while making any order of transfer, especially when the same is provided under the Archival rules governing the school. Now they say that under the Archival rule. Now let us see the rules introduced by the school. Now, after two societies were amalgamated, my lord, they said they have introduced these rules. Lordship, kindly come to page number 25 of his affidavit. This is the minutes of the Archival's Board of Governors decision. Page 25. It was adopted on 5th April 2017.
Yes.
On the top.
Yes.
And the relevant portion would be page, my lord, 30. The amendment they have mentioned there.
This meeting was held on 5th.
My lord, 5th April 2017. And the relevant portion, Lordship, kindly see page 30.
Yes.
Now, and it says, petition number 13, addition in Archival rules and regulations. Now, they have introduced present position and additional positions. Well, what have introduced? Now, A, it says Roman 1, presently no competent tests are being conducted to assess the suitability of principal teachers of the ARPS. Now, in the second petition, I challenge this one also. For the time being, we'll leave it aside. 2, my lord, Roman 2, presently, the permanent regular teachers are not being considered for transfer after 3 years of regular service. That was the position prior to amendment, prior to April, 5th April. Now they said amendment is introduced, my lord, the right hand side. Transfer of all permanent teachers of ARPS after 3 years of regular service. So they have introduced this one. I've challenged this one. This provision also. Now they admitted that earlier there was no provision. So the argument taken by my friend in para 12 and 14 that it flows from clause 15 is incorrect. What they are relying is, my lord, because of the amendment. Now the consequence of legal aspect, Lordship, kindly examine whether the service condition, a person, employee who acquires certain vested rights after his appointment, whether that right can be taken away subsequently or not. The citation we will submit. According to us, my lord, the authority cannot take away that rights. Once I appointed in a station school, my lord, I cannot be transferred. Decisions are also, the one Supreme Court decision is there and Calcutta High Court decision is also there. So this is the position, my lord. This is the position. Now, when we come to the judgment, now, Lordship is, the judgment is, right. My first place, the Supreme Court decision, my lord. My lord, since the Lordship desire, the reported one, we will give it. This is AIR 1960, my lord. We will give the proper one. Citation is mentioned there.
The other case.
My lord, the new one, new decision. It's a 1960 case, my lord. It is mentioned there. Here also what happened, my lord, employee was appointed in one place and he was transferred to another place. At the time of his appointment, transfer was not a part of the condition.
Yes.
Yeah. I don't.
Para?
My lord, this do not indicate say para. Start from page number 3.
No. Page 3.
Page 3. May I read with lordship permission?
Please.
My lord. Learned counsel for the appellant raised before us the following 2 questions. The right to transfer an employee by an employer from one of his concern to another is implicit in every contract of service. 2. The State Industrial Tribunal having held that both the concern, the mills at Amroha and the mills at such form one unit. The appellate tribunal had no jurisdiction to set aside that finding under such of the Industrial Dispute Appellate Tribunal Act 1950. To appreciate the first contention, it is necessary to notice the undisputed facts in this case. It is true that the partners of the sugar mills at Amroha own also the sugar mills at Such, but they were proprietors of the former mills in 19 whereas they purchased the later mills only in the year 1950 and started the same in Such in or about 1955. The respondent 1 to 4 were employed by the owners of the appellant mills at the sugar mills at Amroha at a time when they were not proprietors of the sugar mills at Balanchart. It is considered that it is not an express term of the contract of service between the appellant and the respondent 1 to 4 that the latter should serve in any future concern which the appellant might acquire or start. It is also in evidence that though the same persons owned both the mills, there were 2 different concerns. In the words of the appellate tribunal, the only connection between the 2 is in the identity of ownership, but for it, one has nothing to do with the other. It is also in evidence that an imported workman at Amroha is entitled to house rent, fuel, light, and traveling expenses both ways, while at Such, the workmen are not entitled to any of these amenities. The workmen at Amroha are also entitled to benefits under the call award, while those at Such are not so entitled. The general manager, in which evidence stated that the interim bonus of the Such factory, as ordered by the government in Such was rupees Such, while Amroha was Such. He also stated that bonus for last year at the Amroha would be probably equal to 11 months' wages and such. It is also in evidence that apart from the disparity in the payment of bonus, the accounts are separately made up for the 2 mills. It is clear that the 2 mills are situated at different places with accounts separately maintained and governed by different service conditions, though they happen to be under the government management. Therefore, they are treated as 2 different entities. The question of law raised in this case would be considered in relation to the said facts. The argument of the learned counsel for the appellant that the right to transfer is implicit in every contract of service is too wide, the mark. Apart from any statutory provision, the rights of an employer and employee are governed by the terms of contracts between them or by the terms necessarily implied therefrom. It is considered that there is no express agreement between the appellant and the respondents where under the appellant has the right to transfer the respondents to any of its concern in any place, and the respondents the duty to join join the concern to which they may be transferred. If so, can it be said that such a term has to be necessarily implied between the parties? When the respondent 1 to 4 were employed by the appellant, the latter was running only one factory in Amroha. There is nothing on record to indicate that at that time it was intended to purchase factories at other places or to extend its activities in the same line at different places. It is also not suggested that even if the appellant had such an intention, the respondent 1 to 4 had knowledge of the same. Under such circumstances, without more, it would not be right to imply any such term between the contracting parties when the idea of starting new factories at different places was not in contemplation. Accordingly, the employees would have agreed only to serve in the factory then in existence, and the employer would have employed them only in respect of that factory. The matter does not stop here. In the instant case, as we have indicated, the 2 factories are distinct entities situated at different places, and to import the term conferring a right on the employer to transfer respondent number 1 to 4 to a different concern is really to make a new contract between them. My Lord. Now I'll come to that, my Lord. The last portion, page 6, my Lord. Page number 6. My Lord, may I start from page number 5?
Yes.
at the last portion. It's exactly the relevant case here. We have referred to a decision only to distinguish them from the present case and not to express our opinion to the correctness of decision therein. It would be enough to point out that in all the said decision, the workers had been employed in a business or concern, and the question that arose was whether, in the circumstance of each case, the transfer from one branch to another was valid or amounted to victimization. None of this decision deals with a case similar to that present in the present appeal, namely whether a person employed in a factory can be transferred to some other independent concern started by the same employer at the stage subsequent to the date of his employment. None of these cases hold, as is suggested by the learned counsel for the appellant, that every employer has the inherent right to transfer his employee to another place where he chooses to start a business subsequent to the date of the employment. We therefore hold that it was not a condition of service of employment of the respondents, either expressed or implied, that the employer has the right to transfer them to a new concern started by him subsequent to the date of his employment. May I come down? It is set aside, my lord. A worker has work, but for illness or any other unavoidable cause would be work in a factory during the whole of the second half of the last preceding season would be employed in this season in such a factory. This rule has no relevancy to question raised in the present case. This rule only enjoins upon an employer to employ a worker in the circumstances beyond during in the same factory in which he was working the previous season during the next season also. This does not prevent the employer to transfer an employee if he has the right to do so under the contract of service or under any statutory provision. We have already held that the employer in the present case has no such right. Lastly, it is said that the appellate tribunal had no jurisdiction to set aside the finding of the state industry tribunal, as it did not give rise to any substantial question of law within the meaning of Census Industry Discipline Act. The question raised was one of law, namely whether the appellant had the right to transfer the respondent number 1 to 4 from one concern to another. A substantial question of law involved between the parties, and the raised also an important principle governing the right of an employer to transfer his employees from one concern to another of his in the circumstances of this case. We therefore hold that the substantial question of law arose in this case, and it was well within the powers of the Labour Appellate Tribunal to entertain this appeal. The result, the appeal fails and dismissed with cause. Now, same thing, my lord. Here also the ARPS case. It started from 1980s. Now, the RWs came into being only in 2015 only, registered under Society Registration Act, Shillong. And the amalgamation took place only in 2016 and 17. Therefore, at the time of appointment of all these people, writ petitioners, it was not even contemplated that they would amalgamate each other. They do even not conceive at all that the other Assam Rifle School would be merged together with this. It is a separate entity, my lord. Therefore, the amendment later introduced in 2017 by the respondent incorporating this, transfer, perhaps it may be applicable to a new employees. But a person who has already employed, my lord, they cannot be transferred. Similar case, my lord, the Calcutta High Court also, a person, my lord, the division bench order, a person was appointed and worked in the, my lord, in West Bengal and transferred to Siliguri, my lord. Also, my lord, he was appointed at Calcutta and transferred to Siliguri. That was the question, my lord. And he raised that he cannot be transferred. He cannot be transferred. So that contention, my lord, was upheld. I'll come to that. Para 5, Lordship, can you see? Para 5 and 6 first. Para 5 and 6. And last 38. Para 5 maybe. Yes. The orders of transfer which to form the subject matter of challenge in these 3 writ petitions are from Calcutta to Siliguri unit for Basumetry Corporation Limited. The petitioners who are the appellants before us contended that they are not at all transferable to Siliguri, which is a separate department or establishment altogether. The certified standing orders of Basumetry Corporation Limited do not permit such a transfer from Calcutta to Siliguri, and Siliguri establishment is altogether a new establishment. The Honorable Information Minister of the state candidly assure that no journalist would be sent to Siliguri against his wishes, and although options were invited in accordance with such assurance. indiscriminate transfer order have actually been issued, irrespective of the consideration whether such an employee opted or not to go to Siliguri. The transfer orders were issued to step in to close down the application of the publication of the sunset. The transfer orders are made malified as most of the employees so transfer belong to a union affiliated to sunset. It was contended by Mr. Sanjay Mukherjee, the London Senior Counsel, appearing for the appellants, that transferability of an employee depended on the provision of law governing the service conditions of the employee concerned. In case there is no express provision, the terms of contract of employment would be regulate such a transfer. Even in respect of a government servant, his transferability would depend upon the provisions of law, and if the service rules do not permit such a transfer from one office to another, such a transfer would not be effected. It is precisely after the recital of law on the question by the Calcutta High Court in such and such. Now I come to para, my lord, 38, to save lordship. 38 and 39, may I take 39, my lord, the conclusive portion of the judgment. Conclusive portion.
Yes.
The learned trial judge in the facts of the present case clearly went wrong in going through the question relating to financial viability vis-a-vis the existence of the organization in Calcutta, and took into consideration the economic policy of the management in opening up a new venture in Siliguri. The learned trial judge was also clearly wrong in having taken into account the decision of the Board of Directors of the Passometric Corporation Limited on such, so as to alter the condition of employment by adoption of the Bengal Model Standing Orders under the such 1946 as a service condition applicable to the employees of the respondent number 1. The learned trial judge has also misconstrued the pleadings in finding that the apprehension of the writ petitioner was not a real one in coming to finding that the respondents were not taking steps to close down the publication from Calcutta in opening up a new establishment in Siliguri. Really, on such, the management has taken decision to stop publication of such from Calcutta, and there is no such question of simultaneously publication of such or from Calcutta and Siliguri. The respondent, the learned trial judge, who has a really erred in law in arriving at a conclusion while interpreting the definition of the establishment, industrial establishment vis-a-vis the working department, that no separate establishment has at all been started by the respondent authorities at Siliguri. We cannot persuade ourselves to agree with the submission of the respondent that only steps have been taken to open a new department at Siliguri, even though the management remains the same and the same establishment that covers both the units, one at Calcutta and at Siliguri. The learned trial judge has observed in his interpretation of the definition of the department that it has so comprehensive as to include both Calcutta as well as the Siliguri units to be a part and partial of the one and the same comprehensive whole. The opening of the unit of Siliguri does not mean the opening of a new department in Siliguri, but also opening up another separate establishment in Siliguri. And that being so, para 17 of the standing order does not permit the nature of the transfer impugned. It cannot be held in such a circumstances that the service conditions are quite sufficient for the management to pass the impugned orders of transfer, asking the petitioner to join the Siliguri. We therefore set aside the order of learned trial judge, impugned, quash the order of transfer under challenge, and direct respondent authorities to proceed in accordance with law. The law is very clear, my lord. The law is very clear. When the person was born in the department, my lord, if the service condition of transfer was not part of the package of appointment, it is very clear that the employer cannot adopt another rules and impose upon the employees. That is the law. Here, exactly here, the ERPS also same thing, my lord. All throughout, from day one of the establishment of the ERPS school, no one was transferred till date, except these 5 of them. 5 of them. And this is the culmination of the earlier round of litigation. When the Supreme Court directed them to pay all the arrears, they say that they exhausted their entire finances and they tried to shut down the school. And we came before the Supreme Court. Intervention was made by the Supreme Court. And, my lord, there was a settlement. Later on, my lord, after settlement was made, within a month, not a year, they introduced this amalgamation process. And, my lord, amalgamation took place and introduced this amendment. Is a malified, my lord. Is a pure case of malified also. Now, this is the, my lord, the transfer. Therefore, my humble submission with transfer issue is that, my lord, the impugned transfer issued by the department, my lord, it is absolutely incorrect. And here, one of the case, some of the case may I point out. Now, the writ petitioner number, my lord, 118 of 2017, Sebastian, He was appointed for class to teach class 8 to 10. He's a trained teacher. Now he has been transferred to my lord Manipur school, where only class 19 is not available. Therefore, my lord, a person is appointed for a specific class, and the class is not available in that particular school, and I have been transferred. That indicates the Malafites, my lord. I would understand better if the same class is available, go and teach there. Maybe perhaps that is more reasonable. But the class is not available also. Now, another aspect is that in that resolution, my lord, amalgamation resolution, the rules in resolution, they say that, my lord, this transfer is only applicable to a teaching staff. And now here, out of these writ petitioners, 2 of them are not even my lord, teaching staff. And yet they have been transferred. May I just point out who are those writ petitioners? Well, that is WPC number 122, Prat Prasad Yadav. He's only a grade T staff, madam. He's only a grade T staff. Grade T staff. And another one also, my lord, writ petitioner WPC number 125. He is also not a teaching staff, but he has been transferred.
Yes. He has been transferred.
He has been transferred also. Now, therefore, my lord, the present officers, my lord, controlling the school, they will not know the background of this case. Whoever comes, my lord, is a culmination of the earlier litigations. They sustain that, my lord, grudge continuously, my lord, and resorted to the best thing is remove them, transfer them in the far-flung area so that the school will run properly. So that is also not enough. Now the appointment of these people, they were a permanent appointees. Now they are trying to reduce them into a contractual service. Now the second limb, therefore, the transfer method, my lord, this transfer order is absolutely suffered from Malafites and illegally. They cannot take away the vested rights, my lord. I relied on that judgment. And, my lord, with regard to the amalgamation, my lord. Amalgamation, my friend has raised the issue that I'm not a member of the society, 2 societies. Therefore, I don't have any rights to challenge that one. Right. If that decision is not affecting my rights, I have no business. But if you adopt a resolution between the 2 societies, take away my rights, transfer me to far-flung area where there is no transfer provision. Second, reduce my permanent service into temporary, then definitely, my lord, I have every right to assail that action of the respondents. This is what I am doing. Now my lord, the impugned action of the respondent. Now, in that petition, Mr. McCanby can go versus, my lord, WPC number 217. 217.
Yes.
Here I assail, my lord, 2 parts. One is, my lord, the process for amalgamation is illegal. And number 2 is, my lord, subjecting the writ petitioners for yearly tests to continue the service is highly arbitrary. Now, they have taken the plea, my lord, that they have done the amalgamation in accordance with law, and this reducing the permanent service into a yearly test is in accordance with law. Now, the first resolution adopted, before I refer to, my lord, the Society Registration Act, may I take lordship attention to page number 59. 59.
$59.
59 of the writ petition, my lord. In the writ petition.
Yes.
just. My Lord, may just Lordship, I'm sorry, we stand corrected. May I refer Lordship permission to the affidavit filed by the respondent. The minutes they did not furnish to us, but they have annexed in the account affidavit. The affidavit they filed perhaps on 24 October 2017. Swear by my Lord, Mr. Prabhankar, something. Respondent number 4, 5, 6, and 7. Affidavit. And there, my Lord, page number 7 of that affidavit.
Just a moment. Affidavit
Madam.
dated.
Affidavit filed by respondent number 4, 5, 6, and 7. This is WPC number 217.
Yes.
Madam. Para 7, my Lord. Page 7, page number 7. This is the minutes adopted by the Managing Committee of the RPS School on 7 September 2016
Yes.
for amalgamation.
This agenda number 4.
My Lord, agenda number 4. May I read out, my Lord?
Yes.
Agenda number 4. Merger of ARPS Society with ARWIS. In order to provide better education facilities to the wards of ARPS personnel, a number of schools have been established at different unit location of Assam Rifle for ensuring effective management of the Assam Rifle schools and to provide better and improved education facilities so as to maintain uniformity in administration to the extent possible. And it was felt to put Assam Rifle schools under one umbrella, that is Assam Rifles Welfare Education Societies, ARWIS. All other 41 schools less ARPS Light Corps are already part of ARWIS, which is registered with the Meghalaya Society Registration Act 2015. ARPS Light Corps was raised in Census 1980 and had earlier been registered with the Meghalaya Society Registration Act, such. The principal proposed that ARPS Light Corps be also placed under Assam Rifles Welfare Education Society, ARWIS. So this was the first resolution of the Managing Committee for merger exercise. And this was placed before the governing body, the higher authority, page number 11. Page number 11. And this resolution was adopted on 28 September, governing body.
This is also agenda 4.
My Lord. Here, my Lord, the page number 2, Lordship, may I see all the members of the governing body, these are the high-ranking officers of the Assam Rifles. And even page number 12, even the education director of Government of Meghalaya is represented. Page number 12. So yet they say that it is a private school. Private school. Now, agenda number 4, my Lord.
No, having members who are officials,
Yes.
would that make it official?
My Lord, what business they have? They are representing on behalf of the state as a representative of the state government. Education director, although director, his name, Mr. Ram Singh, what business he has? He did not go there as an individual person. He represented as a director of the government of Meghalaya. That is the thing. And director, this Major General others, but what individual business they have? This also is established by him, by his family, individually. It's established run by the Assam Rifle. Therefore, he went and sit as an officer of the Assam Rifles. Well, therefore, the plea taken by the respondent that it's a private school is absolutely incorrect. Now, the resolution we will see, agenda number 4. Well, agenda number 4. It says conversion of ARPS registration to RW from ARPS Society to RWIS. It says, in order to provide better education facilities to the wards of the Assam Rifle personnel, a number of schools have been established at different formation unit location of your Assam Rifle for ensuring effective management of the school, my lord. This is the same adoption, my lord. Well, so they now it says Roman number 2. While agreeing in principle, the chairman took the views of all the other members present. Unanimously, it was decided that the ARPS society be amalgamated with RWS for better administration of ARPS Light Corps and bring parity to all schools run under the aegis of Assam Rifles. Assam Rifles. So this was the resolution. And later on, my lord, they said this was approved by the sub-registrar. Now that approval, Lordship, kindly see, come to my writ petition, page number 65. Writ petition. Well, this was written to the Registrar of Society, respondent, for his approval, written by the Deputy Commandant on 4th October 2016. It stipulates that, my lord, the Assam Rifle Public Society Light Corps was registered under the Meghalaya Society Registration Act on 1981. Also, 41 schools being run by Assam Rifles in various parts of the Northeast were registered under the Assam Rifles Welfare Education Society on 2015. For ensuring effective management of the Assam Rifle schools and to provide better improved education facilities so as to maintain uniformity in administration to the extent possible, a need has been felt to put all Assam Rifle schools in inclusive of ARPS school under one umbrella. Therefore, decision for amalgamation of Assam Rifles Public School Society with Assam Rifles Welfare Education Society was unanimously taken during the ARPS governing body meeting. It's the ARPS governing body meeting on September such and such under the chairmanship of Lieutenant Governor such and such. In view of that, you are requested to issue no objection certificate for the amalgamation, please. So this was the approval sought. So now in response to this, my lord, the sub-registrar has given his approval, page number 66. He has given his approval. Well, now, they have admitted two things, my lord. For amalgamation exercise, first, the agenda was moved by the managing committee of the RPS school. Second is, my lord, that was placed before the governing body, the highest body of the RPS. They adopted, and they sent it to the sub-registrar. Sub-registrar has approved it. Now, thereafter, my lord, the amalgamation took place. The affidavit filed by the sub-registrar, they do admit, my lord. I just point out, my lord. Affidavit filed by the registrar, dated, my lord, 30 August 2017. It is sworn by Mr. Abhishek Pagotia. Well,
Yes.
my lord. Now,
Yes.
Lordship may kindly refer to relevant para is para 8 and 9. And 11, para 8, 9, and 11 is relevant. He also admitted that would
Mr. Resu, how long will it take?
may take, my lord, 15-20 minutes, my lord. Some other points.
You have to reply.
State my friend also, KP also yet to give reply.
So we'll continue in a second half.
Lordship. 24.
24.
Lordship. This was the matter where only the victim's statement was required to be supplied, Lordship, for 482. Lordship recollects the 2 wives. So we have supplied. Lordship may pass. Lordship may pass orders. Whatever.
So 1 week.
Lordship may pass the order. We will not argue anymore.
It may be reserved for judgment, my lord. My lord has already heard. Sir Bhattacharjee also was there, and the petitioner were there. They are quashing, and the petition is for quashing of the POXO case, and we are saying that no. Because they are going by the Garot customary law where it allows
First wife, 2 wives. And
so that was the plea. So we had objected, but I don't want to make any more submissions on it. So it may be reserved for judgment after.
Only, my lord, the statement of the victim was recorded before the court. So I have supplied it. Lordship may peruse the same and pass necessary orders.
24.
24.
On pre-made by the parties, this matter is reserved for judgment.
Lordship. Much obliged.
My lord, I beg to mention item number 17. It is regarding hoardings. On behalf of the respondent, my lord, I pray if the matter can come up after 2 weeks, my lord. Item number 17.
On pre-made by the respondent, place this matter to 1 week.
My lord, I beg to mention another item, item number 12. It is a criminal appeal, my lord. Mr. P. Yobin is there. I have taken his consent, my lord. If the matter can come up next week, my lord, anytime next week.
Then let it after 2 weeks, my lord.
After 2 weeks, my lord. Item number 12.
On pre-made by the state respondent, not objected to by appellant, place this matter to 2 weeks.
Highly obliged, my lord.
Please, Your Lordship. I'm beg to mention item number 25, my lord. This matter can be taken up next week because
You are for?
I'm for the petitioner, my lord.
Who's for respondent?
Respondent.
On pre-made by the petitioner, place this matter up to 2 weeks.
Lordship. Highly obliged, my lord.
Please, Your Lordship. Lordship, I beg to mention item number 16, Lordship. It will come after 2 weeks.
Lordship, in this case, actually, I strongly object, Your Lordship, because it may be so time may be given by, but my objection may be recorded because they have keep on taking time. If you go by the record, you'll see that every time petitioner taking time.
So 1 week.
It's from 17. Because of this case, because the functioning of NOCMA is not, it is affecting very much. This is a very urgent case, Your Lordship, but they're taking very lightly.
I think it should be.
Since from 2076, this case has been pending. And there is nothing case in that this one.
On the counsel for petitioner has sought for accommodation in this matter, to which the letter counsel for the respondent, your respondent,
Respondent, private respondent, sole private respondent.
number 1 or 2? 1, 2, 3, 4,
Number 5.
5.
Respondent number 5.
Respondent 5 has strongly objected to the same on the ground that the matter is long pending one. This court, on consideration of the prayer, on grounds of personal difficulty, has would allow the same. This is matter of 1 week.
Lordship.
Highly obliged, Lordship.
1, 2, and 3. Much less was.
May it please Your Lordship, I'd like to mention item number 13, my Lord. I pray if this matter may come up after 2 weeks, my Lord.
13. You're for?
I'm for petitioner, my Lord.
The 2016 matter.
Yes, my Lord.
On prayer made by the petitioner.
After 2 weeks, sir.
This is matter after 2 weeks.
Similar prayer for item number 19, my Lord. As a conducting counsel, Mr. P. Nongwe is indisposed, my Lord.
Item number?
19.
You are for petitioner.
Yes, my lord.
On pre-made by the petitioner, list this matter up to 2 weeks.
Much obliged, my lord.
May it please your lordship. Lordship, I beg to make a mention of item 20.
Who's for the other side? On pre-made by the appellant, list this matter up to 2 weeks.
Lordship, a similar prayer for item 15. Lordship. Lordship, this would be a joint request from both parties to have the matter adjourned.
It's also 2017 matter
Lordship,
on pre-made by the parties. List this matter up to
I'm from the respondent 1, 2, and 3, Your Lordship.
2 weeks.
much obliged, Lordship.
Your Lordship, I beg to mention item number 18. May I request this item be taken up after 2 weeks, Your Lordship?
Yeah, for
The petitioner. Item number 18, Your Lordship.
No objection, my lordship.
on pre-made by the petitioner, list this matter up to 2 weeks.
Much obliged.
Friend will perhaps take some time, my lord. So as far as the state respondents is concerned, my lord, I'll be having some difficulty, my lord, today. Giving reply. I'll have to go.
I think we will finish it first.
I was thinking at least today we'll
Yes, my lord, we also want to finish. My lord.
Otherwise, my lord, as far as my response is concerned,
Okay, we'll do one thing. Let them finish. That day after tomorrow.
on the 5th, yes, my lord. 5th is okay.
Day after tomorrow is 5th. So we'll.
My lord, day after tomorrow I have some fixed matter. Lordship has directed for that inquiry in the Nongpo case.
Oh.
And it is fixed on
My lord,
date
may
field. That is why.
I have one small suggestion. If he can submit whatever, my lord, he has to submit, he can leave, my lord, by that.
No, that is quite difficult.
My friend will have to complete his submission.
He's a key party. I challenge his action.
Could reach somewhere by 2:30.
May I
Okay, then
suggest?
6 then. 6, Mr.
My lord, I'm sorry to mention my father is not keeping well, so I'll be out of station from 6.
Okay, then you do one thing. You suggest a date.
My lord, may I suggest 17, my lord? On that day we will complete. Otherwise, part-time matter it is troubling to
Matter
lordship
is
also.
almost, it has been hard, already been hard.
Yes, sir. But
Only
It's the ending part.
because he's you see, knowing Mr. Sangreso, he will take another 2 hours to reply to what you submit. So,
if you can just
so you'll have to give him that satisfaction.
right, my lord.
So 17.
On that we can complete everything.
Yes.
Let's please make it a point.
Yes.
What my humble prayer would be, Lord, let this matter be taken up as the first item.
I have no objection.
First, last, it doesn't matter.
Yes.
As long as we
It's a
take it up.
part-time matter.
If it is on
It's a
the
part-time matter.
on a priority basis, first item, likelihood that
First on the hearing.
Yes.
Yes.
Come out, no? 17. This matter has been heard in part and on the submission of the parties. The same will continue on the next date. As prayed for, list this matter on 17th as a first and fixed item.
Yes.
On the hearing list.
Yes.
Item number 11.
Devnath.
Mr. Devnath was supposed to respond.
Your Lordship, in Dansani Rana, this what's in my thinking at the moment, Your Lordship, because I have tried my level best to have some instruction from them, nothing has come up. So whatsoever I feel, Your Lordship, here in this case we have taken the stand because he belongs to Hindu. So in my affidavit, whatsoever given, and regulation, the Assam, the Assam regulation, whatsoever we have given the copy in our, my learned friend also given, my also given. So taking into the consideration of these matters, so this could be passed the order. Unnecessary delay the matters is not wise.
Okay, so
Because here only my submission is the receipt. This in our affidavit is given as per Hindu Acts. Thus it is not permissible. This is the first legislation, and then after it's given that it is permissible if the central government gives the permission. So here in this case, preliminary is allowed as per regulation, subject to condition, and this on this condition the person who is employed in the Assam Rifle, he should inform to the commandant. So this is only, and he has not informed. So this is the difference, nothing. So ultimately, central government permission stand, and central government authorized by the regulations to the commandant to act it upon on behalf of the central government. So if the commandant also some order was passed, then it is binding. So this is the matter, only this, nothing else.
have you filed your written argument?
Yes, my lord. I have filed my written argument.
With all the authorities?
Yes, my lord.
Have you filed yours?
So I also filed it.
You have filed? Yes. With all the authorities?
So I think seriously, the file I it's a misplaced. This one I was not getting the file. So I
My lord, I am relying on SCC 2013 Volume 7, 426. It is I have already mentioned here in my written argument. And then on the Assam Rifle Regulation 2016, Clause 160.
Okay.
I have given a short gist of my argument, short synopsis of.
But you have not relied on any authority, Mr. Devnath?
So other than say, Your Lordship, no authority as such.
No,
It is
no.
just because it is only the statutory provision of this.
It is there. It is a statutory provision.
and
It is
then
binding
after
on them. It is their creation.
Then if you go to the statutory provision of the Pension Act, then CCS pension rule, so it is covered in the pension rule. Then if you go even subsequent stage, that what is the central government publication notification, then we will come to the regulation ultimately, because regulation if it is given to this and it is binding to the Assam Rifle, and it is binding to them, this it is the order of the central government.
Okay. Parties have been heard. This matter is now listed for, and this matter is now reserved for judgment.
Item number 14.
I think 14 is Rajiv Kumar Sarkar, no?
Yes. So, who's appearing here?
So in the BDEC,
He's not here.
not here. So in this case, Your Lordship, in another case in Rajiv Sarkar, I think this one already heard and it is reserved for judgment. And he was saying this matter will come up after the outcome of this earlier one.
Oh. On premier by the respondent, who has submitted that this matter may be heard on after the disposal of, what is that case?
Case number is, I forget now.
Punto of WPC number 144 of 2006, since the outcome of this case, the outcome of the said case would be relevant and material as far as the issues raised in this petition is concerned. On preamble, this is matter after 3 weeks.
Item number 51.
Filing written arguments, Your Lordship.
Lordship, even me, Lordship, I am so ready with the written argument. Come.
Mr. Singh, you are appearing for all the
Respondent, Lordship, respondent number 1 in all the MSc appeals, in the 3 appeals, Lordship. Lordship, as a matter of fact, my learned friend from the appellant, it was already heard from his side. He has already done, given his submission.
Oh, you have not?
On the last date, even from my side also, I have already given. My only leftover was only to refer to the judgments only, so which I have already annexed in my written argument. So, Lordship, if Lordship is kind enough, then I can just read out briefly my written argument. It will take only 10 minutes.
Your Honor, if it will be taken next week because my senior is not present, he's indisposed today.
But Lordship already has been heard already. This case has been lingering, Lordship, and I have been deprived of for long years, Lordship. So my only submission.
But he has to be, see, Mr. Singh. One thing is, the court has to ensure that all the parties are heard.
He was already. He has.
He was. But then once you reply on law point, he may want to,
I'll supply to them the copy.
You have not given.
No,
So give him.
I'll give them now. They have not given. They are the appellant. So I was waiting whether they are ready or not. Lordship.
Okay. So you give it to him. So when do you want it?
So next week, Your Lordship.
Next week. So next week we'll do it.
Actually, it will be done kindly. Lordship, may it be kindly fixed on Tuesday and Monday also. I think holiday, because other days I may have to go out.
Yeah. So you suggest a date.
Tuesday.
Tuesday is occupied. Your Honor. Wednesday is.
Okay. Wednesday.
Lordship, direction may be given. Lordship, positively they should appear.
No. Would you like to have it on Wednesday or Thursday or?
Wednesday.
This week.
Day after tomorrow.
This week also, Wednesday also can be done, Lordship.
Day after tomorrow, Your
If they are ready.
He'll be here, Lordship.
Yeah.
He'll be here.
Oh, but day after tomorrow we have that other case also. Could you senior do?
Or Thursday also.
Okay, Thursday then. The parties have filed their respective written argument. However, the learned counsel would submit that they may be allowed to reply to the contention raised by the respective parties on law points. As prayed for, this is matter on 13th. 13th, okay? It's a Thursday.
Thursday next week.
Next week. Whenever you are convenient.
This week is not possible. Lordship.
Oh, this week? Sorry. This week is 6. 6, okay?
Yes, Lordship.
This is matter on 6th.
Obliged, Lordship.